The topic of my presentation will be Jewish law and Russian procedural law, theory and practice. I would kick off with a personal note and explain why is it relevant to what I'm doing as a partner in Brian Cave on an everyday basis. So first of all, being an observant Jew, an American law firm in Russia, it's an inconceivable combination of things if you would say this like 40 years ago. And now these sort of combinations and challenges are present, and also the fact that we have discussion in the Moscow State University, sort of this whole picture is completely sort of miraculous. But it also brings interesting challenges in our lives. So over the last years, I had a number of interesting dilemmas when dealing with my clients, and some of them directly relate to the question of Jewish law and Russian procedural law and court system. So it is not uncommon now when you have two Jewish clients coming to me and sort of discussing potential litigation. So as a lawyer, I have to advise one of these Jewish clients, and as observant Jew, I have to sort of convince them not to go directly to the Russian court as a matter of Jewish law. So usually what I have to do is basically either convince them to start the dispute in the Beis Din or decline to act. That happened a couple of times over the last years. Sometimes you have to find a compromise. And when two Jews are not prepared to go to Beis Din, the sort of neutral option would be, in my case, to suggest a mediation procedure, which would not be strictly speaking a Beis Din, but in terms of avoiding Hilul Hashem, desecration of God's name, that's much better than going into the state court. That's kind of a set of challenges that I face as a lawyer. In terms of arguments that I use when I convince my clients to start with Beis Din is the usual set of sort of advantages of Beis Din, which is confidentiality. Obviously, as it was mentioned in the previous presentation, sometimes it is abused, but generally confidentiality is a good thing, similar to any arbitration. Then it's cost efficient because usually the judges, the in the Beis Din, they charge on hourly rates, which are lower than in secular arbitration. The key, most important factor is avoiding Hilul Hashem, and if sort of secular Jews wouldn't exactly understand what it means, usually it's easy to explain in the categories of like reputational damage, like negative PR, etc. So I've seen a number of cases when actually it was possible to persuade Jewish litigants to go to Beis Din, and then when you sort of accept this, there are a number of challenges in choosing Beis Din, and I'm sure Rav Pinchas will cover some of these challenges, and I'm sure he faced the same challenges. And one of the issues is that it's quite hard to find a neutral Beis Din in real life, because usually there will be a question of neutrality of particular Beis Din, and one of the parties often argue that another party was contributing significant charity to this particular synagogue where Beis Din is located. And then the parties go to another Beis Din and the same situation, and yet another one. So in one of sort of high-profile cases I was involved in, two noble Jews tried three forums, and they didn't find neutral forum in Beis Din. And they tried in Russia, they tried in Israel, but at the end of the day, that they ended up in a secular court, but that they exercised sort of all their options really, and they tried really hard. So to find Beis Din which will be acceptable to both parties is a practical challenge, but it's something which is surmountable, but it takes some sort of commitment from both parties to find Beis Din that will be acceptable to both of them. And obviously, in terms of enforceability of Beis Din judgments, in Russia we don't have precedents of doing this, unlike places like New York, where you have a lot of case law dealing with enforcement of Beis Din, and you can sort of have a pretty good sense of how this would work in New York courts. In Russia, the paradox is that, legally speaking, there's nothing that prevents you from enforcing most of Beis Din judgments in the Russian courts. I'm saying most because obviously there are some limited cases where the Russian courts would have exclusivity. There are limited cases when Russian courts may vacate Beis Din judgment. But generally speaking, it's very similar in terms of the risks of non-enforcement as it would be, say, in New York court, based on the legal position. And this sort of remains the same after big reform in the Russian arbitration procedures. And at the moment, the best legal solution would be to have ad hoc arbitration courts with Dayanim as sort of a part of this ad hoc arbitration. And then if you draft your arbitration clause properly with reference to Beis Din as one of these ad hoc arbitration forums, then legally you would be allowed to go and enforce your judgment in the Russian court. The reason why we haven't seen any cases of such enforcement are not completely legal, we should say, because a broader concern is whether such sort of practice of enforcement of Beis Din judgments would lead to like other religious community to follow this example, and how this will be sort of interpreted in the political context. So it becomes more of the sociological and political problem rather than legal one. And for the moment, we don't have the presence of enforcement in Russian courts, and also we don't even have sort of proper attempts to structure Beis Din as an arbitration forum. And this has a number of problems for sort of incentivizing people to go to Beis Din, because if you don't have Beis Din structured as arbitration forum, then basically it affects your limitation periods. So, for example, you have 1 year limitation period for transaction, and you go to Beis Din sort of acting reasonably and sort of respecting halacha, but then this becomes protracted arbitration in Beis Din, and 1 year passes, and you lose your right to go to the secular court, and you didn't achieve a result in Beis Din. And if you would structure it as arbitration, then limitation periods would apply, and you wouldn't lose your right to go to secular court. But because you intentionally or non-intentionally are not structuring Beis Din as an arbitration forum, then you have this downside, which could be avoided if you properly structure Beis Din as an arbitration. So I think that there are sort of arguments to start trying structure Beis Din as an arbitration forum, because then you have more arguments to convince members of Jewish community to follow this route, because you can say that basically you don't lose anything, the limitation periods are still with you. If you don't reach agreement in Beis Din, in the worst case scenario you can still go to secular court. So there are a lot of advantages in structuring Beis Din as a proper arbitration. Obviously, even if this happens, there will be a number of grounds for invalidating Beis Din judgment. Most of them are on procedural basis. Bigger concern that some of our lawyers have is that whether the Russian court would treat Jewish law as governing law of the contract as a problem in itself, from separation of like religion and state as a constitutional matter. And we wouldn't know whether it's a real concern or not unless we have a testing case. But for example, in a similar situation in the States, the state courts are quite receptive to the idea of Jewish law as a governing law. And in the States, you have the same constitutional principle of separation of, as it's called, church and state. And nonetheless, it still works. So hopefully the approach in Russia will be the same, is that it's not a question of violating this principle of separation of religion and state, as long as the actual judgment of Beis Din doesn't contradict what is called public policy, elementary prohibits Russian law. But to be honest, sort of having insights into both Russian law and halacha, there are very, very few cases when this would be a case. So generally speaking, we would be able to expect sort of low percentage of vacation of Beis Din rulings on technical basis. So I'm personally optimistic about the prospects of Beis Din judgment being enforced in the Russian courts, and I think the mere fact of this conference is a small but important step in this direction, and hopefully we will see test cases in the future, and hopefully they will be positive. Thank you.
I believe now we have more time.